elaborate submissions by both the prosecution counsel and the defense team of advocates. At the outset, I would like to decline the invitation to have the investigating officer, Chief Inspector Kamau, cross-examined by defense counsel on the contents of his affidavit. The reason being that the prosecution's submissions were entirely based on the contents of that affidavit, to which all the defense counsel have been able to controvert at length through their submissions. Secondly, it is the modus operandi of this court not to allow cross-examination of the investigators, as that takes a lot of time and delays the court cases. Again, I wish to reiterate that the contents of the affidavits can always be challenged through rigorous cross-examination, and I think the advocates have done well. I believe I have accorded all the defense counsel sufficient time to make their submissions, and they will not be requiring that Chief Inspector to be cross-examined. Coming back to the main issue for determination whether to release the subject minors on bond bail at this stage, I would need more time rather, and in fact a lot of time to consider the authorities that have been cited, the submissions that have been made by both the prosecution as well as the defense team before coming up with an elaborate ruling. Finally, it is again the modus operandi of this court to consider the views of the victims before releasing any suspects on bail, bond, including the subject minors. I therefore direct as follows: the probation officer stand up. You shall prepare an elaborate report. You will interview the following persons. You will interview the parents of the deceased children. Get their views as to whether these subject minors should be released on bail, bond. You will interview the school administration as well. You will interview the lead investigating officer, and you'll interview the children as well. It therefore means that the ruling on bail cannot be delivered at this juncture. Having made those remarks, I would request the parents of the minors and the defense team to implore the children to be patient. Justice moves very slowly in murder cases. It will move very slowly because the victims are many, the minors are very many. It means the probation officer has to go to one home, interview one parent, interview they know how to do their work, go to the next home. You are therefore looking at 2 months before I can get that report, so take a deep breath and rest. That ruling will be delivered in September when the court resumes from recess. So I want to give you a date for mention for directions on the murder case. In the meantime, pre-trial shall continue in the intervening period. So the ruling will be delivered I'll mention first to confirm whether the reports are ready. So we'll give you a date in September. Give the date, Monica. 22nd of September to confirm whether the pre-bail reports are ready. Having said that, there is an issue that has arisen. I have read the children's files. Where's the children's officer? Can I have the notes I made? Where's the children's officer? Where are they? Can I have the white files? I am done with this murder file. Mention, virtual mention, not physical, virtual mention. Then I will give you a date for physical mention, virtual mention. So that closes the proceedings in the murder file. Now I'll convert myself into a children court. Before you leave, there are issues which we have to raise. I'll record in one. I have read the reports, and there are certain issues that the parents need to know. You don't need to stand up. The parents, the children's officers have done a very good job. But I've read all the reports, and these are the issues that arise from the reports, the comments by the children who are interviewed separately.
We acknowledge that this is a matter that involves children as subjects in this criminal matter. We also acknowledge the constitutional provisions that deal with children. their best interests at all times, and how they should be treated when they come into contact with the justice system. Melody, we have also gone through the Children's Act 2020 and acknowledged the provisions that deal with children in remand and the circumstances that can be put in place to allow them to remain in remand during their court matters. Melody, this offense is one of gravity and was conducted in a school.
Watch my pen as you proceed.
Where we lost 16 young female lives in a most horrendous manner. And by all accounts, the suffering that these victims felt was so graphic in nature that rescuers are still undergoing psychological support. Melody, we have today taken plea of 8 subjects for the offense of murder. We must not forget that 16 families have lost their loved ones, and we still have many more children suffering physical injuries, emotional and psychological injuries. Melody, in our affidavit that we have filed before this court, we have taken the court through the investigative steps taken by the investigating team, the substantial evidence that has so far been collected. Melody, I'm referring to paragraphs 6, 7, 8, 9, and 10. We have also referred to the numerous meetings, coordination, and planning conducted by the subjects in this matter. We have also stated in paragraphs 13 and 14 that most of our witnesses are minors who are known to have interacted and had close acquaintance with the subjects in this matter. That these minors who are our prosecution witnesses are well known to the subjects, including family backgrounds, places of residence, and associations. My lady, we have also enumerated in our reply, in our affidavit, that the risks of releasing the subject matters at this time are numerous. And would lead to direct interference with witnesses, intimidation of vulnerable minors, a likelihood of absconding, and would interfere with public perception and administration of justice, my lady. My lady, we are aware that for denial of bail bond, especially in children matters, we must have compelling reasons. And that is why one of the items we have attached in our bail affidavit is a statement of one of our investigating officers who directly linked.
You have attached what?
Yes, we have attached a statement
Oh, okay, statement,
of
yes.
one of our investigating officers,
Yes,
which gives a summary and directly links the subject matters in the commission of this offense, including their preparation and coordination.
I want mine in color form. Preparation, give me the original for the court. I can see the copy already and I don't like it. I want an original one.
Yes, my lady,
Yes.
get an original.
Yeah, continue.
My lady, as we move forward with this matter, we must keep in mind that while the subjects are children, we must also protect the victims in this matter. Who includes the families who have lost their children, the children who are vulnerable witnesses who will be testifying in this court and would need court protection. We should also be looking to protect the same subjects that we are dealing with, from outside harm, including public perception, and further psychological harm that they would experience interacting in a public setting at this stage. My lady, denial of bail bond does not always play a negative role. In these exceptional circumstances, it can also play a protective role. For the subjects in this matter. My lady, I believe with the details that we have given in the affidavit, I look at our bail bond policy. The provisions for protecting children in our laws, together with international perspective, I believe the prosecution has provided compelling reasons to indicate that there is a need to protect vulnerable witnesses. There is a likelihood of intimidation or interference with witnesses and the investigation of this matter. That there is a real risk of reoffending given the steps that the subjects took to bring about this offense we're here in court to today. That the risk of releasing the subjects at this time would expose them to a real risk of harm, both physical, emotional, and psychological. That the role played by each subject has been articulated by evidence, substantial evidence, my lady, and there's a real risk and there's real possibility of having them found responsible for this nature of offense. My lady, we have provided compelling, forceful, and strong evidence to have the 8 subjects remain in custody at this time as we begin the process of hearing this matter in open court, my lady.